The recent Supreme Court case of the City of Boerne versus the Archbishop of San Antonio raises some interesting questions about the role of religion and the role of government in our lives. On Austin Faith Dialogue today, we explore those issues. Stay with us.
Austin Faith Dialogue, at the crossroads of religion and life. A series highlighting the cultural and social interactions between the worshiping and religious communities in and around the capital city. Austin Faith Dialogue is brought to you by the Austin Metropolitan Ministries in cooperation with KXAN. Join us now in Austin Faith Dialogue.
Hello and welcome to Austin Faith Dialogue. I'm Sandy Wilder, your host today, as we talk about the Religious Freedom Restoration Act and all that that means for our lives. And our guests are Professor Douglas Laycock from the UT School of Law and Eric Cernyar, a recent UT Law School graduate and now a briefing attorney with the Texas Supreme Court. It's good to have you both. Thanks for being here.
Thank you.
And to set the stage for the particular discussion, I think it would be helpful for people to know a little bit about your individual backgrounds and areas of interest. Eric, we'll start with you.
Well, I have an electrical engineering degree. I just graduated from law school in May. I'm working at the Texas Supreme Court for Justice Gonzalez. In 2 years, I'll be doing intellectual property, which includes patent law, copyrights, trademarks, and trade secrets. So that's my specialization.
And you worked with Dr. Laycock some on this particular case, is that correct?
Well, I had the privilege of helping him do a little bit of research through the legislative history behind the 13th through the 15th Amendments of the Constitution.
Okay.
Over Christmas.
All right, thanks. And Dr. Laycock, your particular area of interest, or one of them at least, is the whole notion of church-state issues, right? You've worked on that throughout your career?
That's right. I've taught in law school since 1976 and do some litigation on the side, but have studied church-state issues all that time. And when I needed people to work long hours at no pay or Christmas vacation, I tapped Eric.
A good volunteer, it looks like you had. Well, as we get into the larger issues of what the particular case before the Supreme Court might mean, maybe we ought to take a look first at that case and just set the stage, especially for those of us who don't know the law professionally. The city of Boerne the church brought suit against the city in Boerne for not being allowed to expand its facilities. So describe a little bit about the work you did and the particular arguments you prepared in that case.
Well, you know, the basic dispute in Boerne is pretty simple. This is a church that seats 230 people. It was built in 1923. The city, and in particular the suburban area around the city, we don't think of suburban Boerne, but suburban Boerne is booming, and the church is now far too small for the congregation. And in fact, when they finally moved and began holding services in a kind of an open shed, the Senior Citizen Center, that has been very helpful to them, but it doesn't look like a church. Mm-hmm. When they had all this big space, suddenly 400 more people started coming to Mass every week. So 400 people have been unable to go to church on Sunday morning because of this policy. And the city's position was, we will not give you a building permit to expand your church until you first agree to maintain forever this 1923 church, which is in our at the edge of our historic district. And as a practical matter, that meant a huge amount of money invested in repairing and permanently maintaining the church, and the natural place to build a new church is gone because the old church is standing there in the way, and they've eventually had to tear down, or they're going to have to tear down the parish hall and kind of hide the new church behind the old church. So it was a very serious intrusion literally into the right to worship, because these people couldn't build worship space unless they first did all these other very expensive things.
Okay, so the government's statutes about historic preservation versus the church's desire to grow and expand. And Eric, then, as you did some background research, why did you look at the particular things you did in this case?
Well, Doug Laycock needed to have a lot of just basic work done reading through a very large volume of history, of comments made by different legislators debating the ratification of the 13th, 14th, and 15th Amendments to the Constitution, which we were arguing gave Congress the basis for passing the Religious Freedom Restoration Act and enforcing the First Amendment, namely the Free Exercise Clause, in the way that the Religious Freedom Restoration Act did, which was to require essentially the government to accommodate religious practices if a regulation was to substantially burden it, unless there was a compelling reason not to accommodate it. That's just restating it in a way that people may understand.
The argument then that you all presented was there wasn't any particular reason to keep the building?
Well, there's certainly no particular reason to keep the building. It's not an historic church. It was built in this century. But by the time the case got to the Supreme Court, what often happens in litigation happened with special force in this case. The issue had been abstracted from the actual facts in Bernie, and the Supreme Court wasn't interested really in the historic district or 400 people who couldn't go to church or anything that happened in Bernie. It had become by the time we got to the Supreme Court, a dispute between the two branches of government, between Congress and the Supreme Court, about their relative roles in protecting the liberties of the American people. And it's a little complicated to explain to lawyers, and it's very complicated to explain to non-lawyers, but basically Congress wanted to provide greater protection to religious liberty than the Supreme Court has been willing to provide since 1990. And I think the simplest way to think about the difference is, what did the church have to prove to get permission to build a new church in Bernie? And under the statute, the Religious Freedom Restoration Act, all the church had to prove was that its religious practice of conducting worship services was being substantially burdened. And if they proved that, then the burden was on the city to justify that burden. The city had to show they really had a very strong reason for not letting them build a new church. The Supreme Court's view of what the constitutional protection for religious liberty means, what the Free Exercise Clause means, is that the church had to prove discrimination. The church had to prove somehow we were treated differently from other landowners in town. And it's a little vague yet on just what that means. In fact, the church was treated differently from some other landowners in town who complained and got left outside the boundaries of the historic district. That might have been enough. But sometimes the Supreme Court seems to say, you have to prove they did this because they don't like Catholics or because they don't like religion. You got to show religious bigotry, in which they couldn't show. That's not going on in Bernie. I think serious indifference to the church's needs is going on in Bernie, but bigotry is not going on in Bernie. And if that's what we have to prove, we couldn't prove anything that would satisfy the court. So the court standard is ambiguous, but it certainly is much harder to meet. And Congress thought the Civil War amendments to the Constitution give Congress express power to protect constitutional rights, to enforce constitutional rights. Congress has always thought that that meant it could go further than the court. It could provide more protection than the court. The court had always said that, had always said Congress can go further. This time, the court said, no, Congress can't go any further than we go. We don't think this statute was needed, and so it's unconstitutional. The practical effect of that is the greater protection for religious liberty that Congress wants to provide is off the books, and every religious liberty claim has to go through this hurdle of first proving discrimination.
Now
you're discriminating against us is what churches or believers have to prove.
Okay, so this was a pivotal case in terms of turning that balance of power and protection.
It was a pivotal case in terms of religious liberty, and it was a pivotal case in terms of congressional power. It was pivotal on two big issues.
And you said just a minute ago, if I heard you correctly, that since about 1990, the Supreme Court has begun to change direction. What do you see having happened since then, since 1990?
Well, we have since, in 1990s when they happened to get a case, but we have since the late 80s a very conservative Supreme Court that believes judicially enforceable constitutional rights, the way we've always protected liberty in America. It's a bad idea, puts it a little too strongly, but only a little, right? That judges should enforce very little, that most important decisions should be decided by Congress or by the legislatures, And even when the Constitution expressly says something like, no law prohibiting the free exercise of religion, the court should give that the narrowest possible interpretation. And they got to religious liberty in 1990, but this mood has been going on since the middle 80s. And they're not entirely consistent about it. Sometimes they're still quite activist, but for the most part, their view has been that individual liberty should be construed very narrowly. That includes secular liberties as well as religious liberties.
And Eric, I remember you said something about that probably the next time a religious liberty is chipped away at, it won't be a shoe falling, but there'll be maybe several little shoes.
Yeah, several little shoes falling.
So what do
I
you
think that
see
a lot of
happening?
the religious liberty suits that go through the courts are not the kinds that would grab the attention of newspaper headlines or grab the sympathies of the majority of the people. Quite often, these cases involve people who have views that most of us would consider ridiculous or arbitrary or just foolish, views that many of us may think that they should just abandon. But once we adopt that kind of mindset, we risk losing respect for our own religious views. Now, there's a large segment of this population that doesn't have any religious views compelling enough that they would feel like they had to obey those and to obey God rather than to obey the state. But our nation certainly has a history and certainly has a large population that does believe that its duties and obligations toward God exceed those toward the state. And Justice O'Connor, in her decision, in her dissenting/concurring opinion, detailed a lot of that history. And I think that we've lost sight of that in our country. I think we've lost appreciation of that. And so I think that what's going to happen is rather than a whole lot of hostile assaults on religious liberty happening across the board, religious liberties are going to be chipped away person by person, church by church, small denomination or small community by community, and we may never notice what's going on until it reaches such a crescendo that suddenly we stop in our tracks and see that something needs to be done. I'm motivated my motivation for getting involved in this case is because I see our culture trending in that direction, trending toward an indifferent attitude toward religion and the importance of religious beliefs. I think that this whole problem's been addressed by Yale professor Stephen Carter in his Culture of Disbelief. And I think that the Supreme Court decision, although it was founded on distinct legal arguments, I think it reflects that cultural trend as well.
Well, let's come back in a minute and talk some more about those trends so that we can know what to watch for. We hope you'll stay with us for the second half of Austin Faith Dialogue.
where we
We're
start.
glad you're here for the second half of Austin Faith Dialogue when we talk about the whole notion of religious liberty and the courts. And our guests today are Dr. Douglas Laycock from the UT School of Law and Eric, I knew I was going to Cerniar. I knew I was going to get it wrong the second time. Recent law school graduate and now a briefing attorney with the Texas Supreme Court. And we left off with you, Eric, as we were talking about how you see the case that was just argued, the Bernie case, as perhaps leading us gently down the slope of perhaps chipping away at some of our religious liberties, and we may not notice.
Well, I think that there are several examples of just small cases that came out after 1990, between 1990 and 1993, when different courts were interpreting the Smith decision that took away that standard that protected religious liberties. And I think Doug Laycock could probably comment on several of those cases, so I'll go ahead and let him detail those.
Okay, maybe you can give us some background then.
Well, you know, I think Gary summarized it very well. That there are very few cases that look like real persecution. And the examples of that do happen tend to involve groups that have a hard time getting the sympathies of the American people. So the so-called cults actually experience governments out to get them. Right? Scientologists and Hare Krishnas and people like that experience things that really look like persecution. But that's not the usual problem. The usual problem for mainstream faiths and even sort of a little bit outside the mainstream, very strong evangelicals, fundamentalist, Orthodox Jews, conservative Islam, Muslims, is much more a sort of indifferent government attitude. The government's the boss. The bureaucrats make the rules. We don't want to be bothered with anyone who needs an exception. These Muslim girls say they've got to be covered all the time. Well, you just got to wear a gym suit in gym or you don't graduate from high school. That's the rule. That's the rule. Don't bother me with this. Right? One that is recurring is happening all over the country. There are hundreds of these cases pending. A member of your church runs into financial difficulty, winds up filing for bankruptcy. Okay? His creditors can now come and sue the church and demand that the church refund all the money he contributed in the last year in some states, the last 5 years or 6 years in other states, and use that money to distribute to pay the creditors. I've got one of those cases pending in the Court of Appeals in St. Louis. I got a call from a pastor in Houston just yesterday. He's got one here. A friend in Utah told me there are 150 of those cases pending in the state of Utah, which we think of as a highly religious state, right? How does it happen? 150 churches get sued in Utah? Well, because in Utah, like everyone else, not everyone is sympathetic, and this view that the church is no different from any other organization, right? No different from a used car dealer or an electrical contractor, fully subject to regulation. If it doesn't like the regulations, tough, is increasingly widespread. Legally, the difference between the church and the car dealer is there's no free exercise of car selling clause in the Constitution. Right? For good reasons, the founder said religion gets special protection. We're going to leave religion alone. And the reason we leave religion alone is because throughout human history, when the government tried to mess with religion, very bad things happened. Right? So there's a special history. It's especially important to the individuals and the churches who believe. It gets special protection, and there is a lot of doubt about that. And because we regulate so much now, we are pervasively getting these low-grade conflicts between bureaucratic regulation and religious needs. Another one that was at the Supreme Court at the same time as Bernie, very conservative Protestant lady in California, owns 4 duplexes, rents them out, got fined $10,000 for refusing to rent to unmarried couples. Well, not many people in California really sympathize with her belief anymore, but for her it's very, very strong.
Growing out of her faith, therefore
Right.
it's a religious liberty issue, right?
Precisely.
And in this case, or in the cases rather of creditors going after someone's church contributions, Are they going after those contributions in the same way that they might go after contributions made to any other nonprofit organization?
In theory, yes. In fact, nearly all the cases involve churches. And I don't know the reason for that, but I have a pretty good hunch. And the hunch is, when you get in financial trouble, why do you maintain your contributions? You got to be pretty strongly motivated. If you think it's a religious duty to support your church, you'll give up some consumer item and keep making those contributions instead. But most people who contribute to secular charities don't have that strong a motivation. So the cases wind up being church cases. And if the credit industry prevails on this, churches will be the principal source of money to pay off creditors in consumer bankruptcies. Because most consumer bankrupts don't have any assets to pay for their creditors. The claim against the church is all there is in most of these cases.
I see the slippery slope there.
And I suppose one other example people should think about, the land use regulation. This case in Bernie, there are land use cases all over the country. In the city of Chicago, it is essentially impossible to start a new church because there's so many restrictions in the zoning laws. Any church requires a special use permit, even if you just want to rent a storefront and use it for church. No new construction at all, just converted to church use. Has to get a special use permit. That requires notice to the neighbors. And if your church is at all unusual, if you're the First United Methodist, you already have a church on the corner. And if you're not, the neighbors say, we don't want you here. We don't want any of these strange, non-denominational, unaffiliated churches. So a lot of those cases, they're cases of Reformed Jews showing up to say, keep the Orthodox Jews out of the neighborhood. They're bad for the neighborhood. People with high religious intensity, whether they're evangelicals or Orthodox Jews or very devout Catholics, people with high religious intensity scare a lot of the rest of us, and they get hassled by government.
But that's not fair, and the law is about fairness. Well, Eric, you speculated that some of what might be happening in terms of clamping down on religious liberty might even be a generational shift, just different understandings of the importance of faith in somebody's life. And I wondered if you might want to say a little bit about that.
Well, I've just noticed, talking to different friends at law school and elsewhere, very few of them were alarmed by the decision that the Supreme Court handed down this June, striking down the Religious Freedom Restoration Act. And I find that a lot of my friends have a highly materialistic, technological, scientific view of life, and a lot of them were raised in Christian families, but they don't take religion seriously. They trivialize religion. They see other religious people. They're willing to associate with them and tolerate them from time to time, but really, it doesn't really concern them too much if they see somebody else feel a pang of religious conscience and trying to decide whether or not they have to follow God or Caesar. And I think perhaps my parents' generation and my grandparents' generation respected religious commitments a lot more. And our new secular generation doesn't really see it as anything but an invention of our own minds. And it's not objective, it's not scientific, it's not something that we see and perceive with our own senses. It's something that just individuals make up. And as such, when you completely divorce faith from reason in that way, and you don't think that it could have any reasonable basis, if you don't believe that God could possibly objectively exist and really truly speak to our world, then maybe it becomes more difficult to respect the religious impulses and the compulsion that people know and understand that requires them to follow their faith and follow the dictates of their faith.
And you're right, that is a shift from seeing faith as a fundamental part of being human to faith as an eccentricity, an odd behavior, something that is strange to many people.
Or something that you just pick up somewhat casually and you can discard it just as easily. That's what I see, and I think it's hard to respect religious liberty and religious free exercise like we respect free speech and freedom of press when we view it in such a trivial way. And I think that that view has pervaded much of the intellectual community, and I think that's why the Supreme Court has held as it does.
You're right. That's worth keeping an eye on. And then that leads me to think of one final question that I believe we have time for, which is the United States then alone in discussing these kinds of issues, or are people of faith running up against religious liberty issues in other countries? In other words, are there some precedents somewhere else?
The United States is one of the most religious countries in the world, and it's one of the most pluralistic countries in the world. So we, I think, have more of these conflicts than most countries, but they certainly do arise elsewhere in very different legal environments. You know, the French are having trouble with their Muslim population, and whatever the law is, the French tend to be very unsympathetic to people who don't want to adopt French culture, whether it's for religious reasons or any other reasons. The former Soviet Union has horrendous problems. They're trying to shift from a system of overt religious suppression to religious liberty, and I was over there 4 years ago. I think their intentions are honorable. They're not really sure what liberty means, and they've got really intractable problems to try to solve. And there's a bill pending the Duma right now that Yeltsin vetoed. So there are things going on around the world. One of the most striking things is the United States is party to an international human rights treaty that sets out a standard for protecting religious liberty that is very much like the Religious Freedom Restoration Act that the court struck down, as we are out of compliance with our international human rights obligations on religious liberty issues right now. No one in Washington seems to care about that, but we are out of compliance. Congress is going to do what it can. I think there is there's talk about a second Religious Freedom Restoration Act. It would be narrower. It would not be based on power to protect human liberty, which is what it should be based on. But it would be based on other things that don't fit nearly as well. It would be a condition attached to government money. It would be a regulation of commerce, which is, it's kind of silly to say to protect religion, you have to protect it only when it affects commerce. But sometimes it does affect commerce, and Congress will use what the court has left it.
So we'll look for ways then in the next several years that our religious liberties are supported and attacked in the public arena. And thank you for being here today. Thank you too for joining us as we talk about these important issues. And we sure look forward to seeing you next week on Austin Faith Dialogue.